During trial, my opponent has spent hundreds of dollars for an anatomical exhibit, a photograph that's been enlarged 30 inches by 40 inches, and that he's been using to help the jury understand the anatomy in this case. Can I use my opponent's exhibit when I question his witnesses? You want to know the answer? Come join me on this walk through the neighborhood as I tell you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, I can, but it can be really awkward asking permission to do that. And sometimes you don't even ask permission. So what am I talking about? All right, here's the scenario. Let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you harm and injury. A medical expert has reviewed all of your records and confirms that you have a valid basis for a case. The defense turns around and says, "What are you talking about? We did nothing wrong. And even if we did something wrong, we didn't cause you harm and injury. And guess what? Even if we did something wrong and caused you harm, your injuries really aren't that bad. And oh, by the way, you, the patient, caused and contributed to your own injuries." Those are the typical defenses we see in these types of cases. So now your case goes all the way to trial. 2 years after you start your lawsuit, your case finally comes up for trial. So now during trial, my opponent has spent hundreds and hundreds of dollars obtaining anatomical drawings to identify exactly the anatomy that's involved in this particular case. And now he's put them on poster board and enlarged them to 30 inches by 40 inches. So they are readily visible in front of the jury. You put it up on an easel, and now they can clearly see what you're talking about. So now he uses this anatomical drawing when questioning his doctor and questioning his experts to explain to the jury exactly what's going on here, to explain to them the parts of the anatomy that they need to know. It's like getting a medical school class, and he's using this drawing to help them understand exactly what happened here. So now when I get up to cross-examine his witnesses, this exhibit, this enlargement, this anatomical exhibit is still sitting on the easel. He hasn't moved it. He hasn't put it away. Can I now use this exhibit to cross-examine his witnesses? The answer is yes, I can. Now, where he has left it sitting up there, it's obvious I can use that exhibit to go ahead and cross-examine his witnesses because they were just answering questions that he had asked using this particular exhibit to help the jury understand what this case is really all about, what the medicine is all about. So it becomes obvious that I can still use this since it's right there. But what happens if, when he's done questioning his witness, he takes his exhibit and now he puts it off to the side and he turns it around so the jury can't see it anymore? Can I use his exhibit? The answer is yes, but it's going to be a little awkward. So while I'm cross-examining his doctor, his expert, I turn to my opponent in the middle of the trial and I say, "Hey, Mr. Jones, you mind if I grab your exhibit and now ask the doctor questions about it?" What do you think he's going to say? He's going to be in an awkward position where if he says no, it looks like he's being petty. "What do you mean I can't use your exhibit? You just asked this doctor questions about things that are contained in this exhibit." Would it be appropriate for me to ask the judge to force him or compel him to go ahead and let me use this exhibit? Well, I guess in the most extreme circumstance it might, but again, then I look petty because now I'm enlisting the judge to compel and force my adversary to allow me permission to use his exhibit. Now, it's understandable. This guy has gone on his own and spent hundreds, if not thousands of dollars to get these exhibits made. But you know something? It works the opposite way too. So my opponent may sometimes do the same thing using my exhibits. And if I were to turn around and say, "No, you can't use them," I look petty. If I turn around and say, "Of course you can use them," now I look magnanimous, like, "Hey, of course you can use them. Go right ahead," as if I have no care or concern in the world. And that's the right thing to do. To turn around and not give it a second thought, "Hey, you need to use my exhibit to question this witness? By all means, go right ahead." You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.